On Radio 97, it's time to talk law for this Thursday morning. Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, with us every Thursday, except last week. She has to have a week off at some point. She brings her legal expertise by providing some general advice on the latest of hot topics. She has experience that spans more than 25 years in the area of property and commercial law. She also prepares wills as part of estate planning and litigation. And she's back with us. Good morning, Despina.
Good morning, Wayne. Good morning, Brooke.
Welcome back. I hope you had a beautiful break. Well deserved.
Thank you. We did. We actually went away to celebrate our 25-year wedding anniversary.
Congratulations.
Congratulations.
It was pretty special. Yeah.
So
Yeah.
nice.
So I did get a week off for that.
And now we're back talking law.
Yeah, for the next 25 years till your 50th. Yeah.
Let's see.
Alrighty, so buying off the plan, so many people are doing it lately, but you do have to be careful of advertising. Marketing, it can be deceiving. And one buyer took a developer to court recently, all because of the photos in the marketing brochure. So Despina, tell us about it. What happened?
Yes, it's a very real issue with off-the-plan projects. And, of course, there are many on the Gold Coast. And this is a case that concerned a off-the-plan project in Melbourne, but still very relevant because the case was heard in the federal court. And the reason for that is that the buyer actually brought proceedings for misleading and deceptive conduct. And, of course, that's under the Australian consumer law, which means it goes to the federal court. So it is very real and very relevant as to what occurs, even though this was a Melbourne high-rise and a project down there, to what happens up here in Queensland. As I said, it was in the federal court. So I thought we'd talk about this because there are many projects, as I said, on the Gold Coast happening at the moment. And given the property market and what's happening with the shift at the moment, as we're seeing, people need to be a bit more aware, perhaps, of some issues that have come out of this case.
Mm-hmm.
So this particular case, as I said, was an off-the-plan project in Melbourne. So it wasn't able to be seen. People had to rely on what the developer provided to them. So this particular case, what was given to this particular buyer and other buyers is what we call renders. So they were actually not photographs because nothing was there to photograph yet. It was actually artist's impression of what an apartment was actually going to look like when completed.
Yes.
And the relevant issue here, there are a few issues, but the point here about misrepresentation is that the artist's impression here, and we have all seen this, if people go and buy off the plan, they'll know what I'm talking about when they go into a sales office and they look at a marketing brochure or they look at something displayed on a seen on their developer's website, or something in the sales office itself on the wall, or something along those lines, representing what the developer says the project and the apartments will look like at the end when it's completed. And this particular artist impression showed this apartment that this buyer actually contracted to buy, which was the same apartment that they said was being used in this artist impression, which is also relevant, showed a massive expanse between an indoor-outdoor area of an apartment building, and the expanse was actually huge. It was very, very wide, and it also showed that the indoor-outdoor area was seamless, so you could move from one area to another seamlessly.
Yeah.
So there wasn't a step up or a step down, and that was something that very much appealed to this buyer. He went under contract specifically relying on this artist impression.
Mm-hmm.
And that was very important. And that was established in the case.
Because when you see the photo, and obviously this is radio, but when you see the photo, it is a very, very wide, obvious opening. We're not talking about a small feature. It was almost like a wall was not there, and it was this beautiful big opening that you can walk in and out of. Yeah, so it's a big feature of an apartment.
You are exactly correct. And that's the whole point. So he relied on this very heavily, and he said, that's what I want. I love this look. I'm going under contract to buy this apartment based on this artist impression. Now, at the end, it was discovered, of course, that this particular apartment could never have been built this way. And the developer knew this because he was advised by his architect, and there was evidence in the case to support that, where the architect advised, you'll never get an expanse more than 3.4 metres.
Okay. So
It just can't be built.
yeah, so that's not what this artist impression looked like.
Exactly. So when the developers give artist impressions, of course there are disclaimers, and they say things like, look, it's only an artist impression, it's not entirely accurate, it'll depend on completion, etc. And in this case, it was the same. There were disclaimers galore, but the judge found all of that irrelevant for a few reasons. One, well, very significant, the developer knew that this could never be built, and that came out through the trial, and the architect gave evidence and advice that, look, you can't build this. So you should be pulling these renders out. You should not be showing people these marketing brochures, but they never withdrew them and never advised buyers. So that was a big no-no, and obviously misleading and deceptive conduct and misrepresentation. That was one reason. But of course, the other reason that the judge touched upon in the case was, it's interesting, and developers, if you're listening, should really have their ears pricked up, is that the disclaimers were in very, very small font and were found at the very end or right at the bottom of a brochure.
Yeah, you see those little asterisks right down the bottom, and you go searching down there for
and
the
it's like,
fine
I'm
print.
sorry, but
There
when
it
you're
is.
shopping
There it
for
is.
a beautiful apartment, you're looking at the photos.
Yeah.
You're not going to read the 8.5 New Romans font at the bottom.
Exactly. So, and why would you do that? And I think over the years, not all developers, some of them don't do that, of course, but some of them do. And you really should be looking at it from a different perspective, which a lot of developers do. And I've seen this in contracts, which is this, that instead of trying to quote unquote hide it, or another way of saying it, rather than focus on a disclaimer that sort of is out there and bringing it to the attention of the buyers, you should actually give buyers the opportunity in your contracts, which is what we do, which we say, look, if there's anything that you've relied on, if there's anything that you've been given where you're relying on this to enter into a contract, put it in this document or list it, and then that will allow the developer to either dispel it or not before you even go under contract. So let's flush it out. Let's get it out there in the open straight up, and then that will actually help the developer down the track if the buyer claims something that they were relying on later on to try and get out of a contract. It's actually to their advantage to do this.
All right, Despina, can we have a look now? Of course, you've, as we mentioned, you've done plenty of these over the years, so you know quite a lot of tips for the unwary. Can you give us a couple of ideas for people who may be in a similar situation, things that they might like to think about and do?
So as buyers, definitely. So what I always recommend to buyers before they sign a contract is, when you do go and meet the developers, marketers and agents who are there representing the project, if you go into a sales display suite or a centre, or if you are given a brochure, whether it's by email, or if you go on the website and you're looking at something that illustrates what a project is going to look like or what they're marketing, you need to take evidence of that and keep it and store it and record it. So if it's a physical brochure, never throw it out. Keep it amongst your records. If you go into a sales display suite and they can't give you a brochure, and there's pictures on the walls, or artist impressions, I should say, and illustrations, go and take your own photos. You go in there and take your own photos and keep those photos. If you've been sent emails by the marketers about what's going to be built, keep those emails because they often attach proposed plans and illustrations of the project. So keep all of that material that was given to you before you sign the contract, in case you need it down the track for evidence, because particularly with display suites for projects, once the construction starts and the lots are sold off the plan, those display suites are demolished.
Gone, yeah.
So they're gone. And often the information on websites can disappear. So if you're on a website and you see something, do a print screenshot.
Yeah.
So that way you've got that recorded as evidence. So absolutely, because you're relying on this information to enter into a contract. And if that information is not attached to your contract in the disclosure material, you should retain it for your own evidence as well.
Great advice there, as always, from Despina Priala. Thank you so much, Despina. And don't go anywhere. Pulling over in an emergency lane. We're talking about this in our next segment. Stay tuned. You're listening to Radio 97.